Customers want fast and frictionless digital experiences, yet also expect protection against breaches, privacy violations, and fraud. Drive engagement by optimizing security and convenience to attract and retain customers. Use the PingOne cloud platform to build, test, and optimize digital experiences. The no-code orchestration engine weaves together authentication, user management, and MFA, all of which can enhance security, drive engagement, and boost revenues. Visit securityweekly.com/ping identity to learn more. Is your team ready to defend against the latest cyber threats? Validate human cyber defense readiness with Rangeforce. Sharpen your team's capabilities with a cloud-based platform that takes a real-world, continuous approach to cybersecurity skills development. Rangeforce empowers cyber defense readiness at scale, with hundreds of interactive modules, learning paths mapped to industry frameworks, skill assessments, and team-based defensive threat exercises. Visit securityweekly.com/Rangeforce to learn more. Welcome back to Enterprise Security Weekly. Do you have a specific guest or topic that you want us to cover on one of the shows? Submit your suggestions for guests by visiting securityweekly.com/guests and completing the form. We review suggestions monthly and we'll reach out to you once reviewed. I just completed all of mine earlier today, yesterday and today. I cleared out the queue. I had some really good ones in there, so thank you for that. All right, for our second interview today, Jennifer Sosa joins us to talk about the SEC's new timeline for incident reporting. Jennifer is an experienced litigator and advisor on issues where technology and the law intersect. She advises a broad range of clients on issues relating to privacy and information governance. Welcome to the show, Jennifer.
Hello.
Fajita time. How do you feel about fajitas?
I feel good about them. And combination for me.
Combination. Very good. Yeah, it's tough to pick one. And it's nice that you get to, that you have the option to not choose.
Always.
Decisions are hard. So you, like Scott, are giving a talk at InfoSec World next month. And if you want to just give us a quick overview of what you're going to be talking about there.
Sure. So recently, the SEC proposed a new regulation concerning the amount of time that publicly traded companies would have to report any material cybersecurity incidents. More on that to come. And so the discussion at InfoSec World is really about, the regulation at this point is still just a proposal. Comments were coming in over the last couple of months, and the conversation will be about, what do these regulations potentially mean? What is their practical impact? What are some tips for companies who are looking at them right now? How can we get ready? So that's what we'll be discussing.
And it's, maybe something to talk about before we get into some of the details is the rationale behind why the SEC is pushing for this. And I think I've seen even outside the U.S., India, I think, has a similar proposal, in some stage at this point. I think it got delayed or something like that. But, sitting here thinking about the reasons for requiring a certain time limit for reporting an incident. I just happened to see earlier today, there was some news of some additional folks that engaged in inside trading on the Equifax breach that happened back in 2017. Like, I think everybody knows about there are a few executives, that had dumped stock before the announcement, but apparently it got even further out to that. And like the husband of somebody involved with PR or something like that also engaged in insider trade. Is that kind of the rationale behind it? Because it seems like, with the SEC involved, it would be a good reason to do this.
Well, I think there are probably a number of reasons. The most obvious is to have transparency with the investing community. And so, right now, you could argue that there's an obligation to disclose any cybersecurity related risk, but it would only come up under a general risk category. So it could be potentially buried in the SEC filings, whether it's the 8K or a 10K. I think it's an attempt by the SEC to normalize what the reporting requirements are, right? The level of detail that has to go into what is being reported, and also the timing. You don't want to have sort of this trickle effect where, you report some bit of it and it gets downplayed, and then later more information comes to the surface, and so on and so forth, right? I think they're just trying to say, here's the baseline, here's what you need to let the investing public know so that they can make proper decisions if the stock is potentially going to be affected by an incident.
And part of the title here keeps on slipping. Has this been delayed? Like what? Why is this getting pushed back? And I think I mentioned I have no idea what the reasons are for India. Also, like I keep hearing that one has been getting delayed as well. Is it because companies are not ready for this, or what's the rationale behind that?
Okay, so the reasoning behind the title is twofold. One, I tend to choose a song lyric for the titles of most of my presentations, so related to the general topic, but also because it is something that you see in the reporting, and even in just the effectuation of a particular regulation, right? We've heard just in the earlier presentation about how things come on board, then there's a delay, there's some editing, revising, et cetera, and the time just keeps getting pushed back, which doesn't necessarily encourage companies to put themselves in a position to prepare for the regulations coming on board, right? So it's sort of a twofold for me about the time slipping by.
And I guess next we can just dive into the heart of it. The term material, I think is one that everybody latched onto when they read the language here. Where you have to report the incident once you determine it is material. How, again, talking about slippery, how slippery is that language?
To me, it's very slippery because you're talking really about a legal standard, right? In a securities context, a material incident, cybersecurity or otherwise, is one that has a substantial likelihood that a reasonable investor would find it to be important. Right. So there's an evaluation that has to go on, and there's going to be some differences, as there have always been, in the opinion of what makes something material to a company. For many years, there have been arguments between law firms on behalf of companies about whether some action or incident rose to the appropriate level of materiality. And I think because that is the trigger here, right? It's not just the discovery of a particular incident, it's when the determination of materiality has been made. So theoretically, an incident could happen, and if we delay our evaluation of it, which I think is not the point of the regulation, but if we do, then we also delay our disclosure. Or if we make some artificial rule for what materiality is going to mean to us, is that also what materiality means to the public at large, right? For instance, if I say this particular incident is material because it was escalated to the executive level, does that in and of itself make it material? What if it happened, but it wasn't escalated, right? So, you have all these different questions about a very squishy kind of evaluation that needs to happen before the information is disclosed.
And then the other definition here is, what's an incident? I don't believe the language says breach, right? It doesn't say incident, something like that. And again, another, like if you don't specifically define this, I guess we just have to wait for precedent to tell us what some of this stuff means. Or I don't know. Should the SEC be the one clarifying this? Or we
right. I'm not sure that is where it should be clarified. Although, I think some of the commentary that's coming in is saying, listen, SEC, take a look at what incident means in other regulations, right? This is not the first time that we've seen regulations that are talking about a cybersecurity incident. So maybe look to them, maybe look to some standards within the industry to define what an incident will be. The way that the language is currently, and I think there was quite a bit of commentary about it, the implication is for a breach, but I think an incident could be something that falls, much shorter of an actual, the large scale breach that we all think about when we think about a cybersecurity incident, right? It could be, some, insider almost theft, whether deliberate or not, right? It could be, even just a loss of data for, not any kind of malicious reason. So I think that is another problem, right? First, how are you sure that it is actually an incident? And also, then decide that it's material to your company.
Mm-hmm. Yeah. And, so I don't know what are some of the tips I don't want you to say everything that you're giving in your talk, but, where are companies kind of struggling here? Where do they need help? What are kind of the some of the key what's some of the key advice that you're giving?
I think that a fundamental kind of requirement or policy that should be happening at companies is that the conversation needs to be happening, right? There's sort of a language barrier at this point, and this is something that we talked about even just in the context of the privacy regulations, right? It's one thing to have legal on one side of the house saying, this is the regulation, this is what it means, this is what's required. And then you have sort of more technical side of the house who says, okay, great, but what does that mean? How do I implement that? And vice versa. If there are difficulties, problems with implementing something that seems very theoretical, that sometimes will prevent a company from moving forward with any type of policy or procedure, right? And since part of the requirement here is providing a description in your, in your reporting about what your policies and procedures are, I would say step number one is to establish them, but also to establish a means of communication between, sort of your CISO and then other executives that don't necessarily have a technical background, right? These two sides of the house, time to get in bed with each other. Can't avoid it anymore.
And does this conflict with any other legislation on reporting requirements? Like maybe state level requirements, anything like that, or does it supersede some of that other stuff because SEC is federal?
It's unclear to me whether it will. It is federal, so typically you would think that it would supersede, although it doesn't necessarily cover everything that is covered by, the state regulations, right? So, as far as like what you're required to do, and the timing in state versus federal. I mean, federal versus federal is a different question also, and that's something that we'll be talking about, sort of a comparison of what this timing means. Who do you report to first, right? Like who are you obligated to satisfy first, I think is going to be a little bit of a complicated issue. But, at its bottom, it's establishing a baseline for having some method, I think, to do the reporting. And that's something that we've spoken about continuously over the last couple of years. It's no longer an acceptable position to say, oh, I've heard about this, or I'm hearing about this, and I'm just going to wait and see what happens. I think that with the privacy regulations, because they came on board a little bit slower, that a lot of companies were not, putting aside time or budget to address a plan or procedure to comply with the regulations. In this instance, if this comes online, let's just for argument's sake say it comes online next month, and you've done nothing. When you go to report, you'll have to report that you've done nothing, right? Your meeting minutes will have said you've done nothing, and that's going to be a problem. So,
yeah, and it's from my reading of this, it looked like it was a little bit more than just time frame for reporting the incident, how to report it in your 8K, 10K, 10Q, what have you. they also want details about your security policies and security strategy. Like I can imagine some. Well, first of all, is that correct? And second of all, yeah, I imagine companies are really uncomfortable with this.
Okay, so in the first instance, you are correct. They are requiring that you disclose your policies and procedures, and then also your strategy, basically, of those members of the board who are, what are you doing to evaluate cybersecurity risk? What is the management that's being put into play, right? So yeah, I think that as a company, you'd be worried because essentially, you are disclosing publicly, not just to your investors, but to your competitors, how you are approaching each of these issues, and also to potential threat actors, right? So here's our policy on cybersecurity. These are the tools that we are using. We have insurance, so we think we're fine, and that's the only tool that we're using, right? So you're signaling to the marketplace in general what your vulnerabilities are. And so I think that's very worrisome, and you've seen a lot of that in the comments to the SEC about, we need to tighten this up as far as just giving, open season on disclosing our, proprietary information.
Yeah, I mean, it's a big challenge, not just in this scenario, but for third-party risk management as well. Generally, you want to know that the third parties you're sharing data with are doing a good job protecting it. And again, companies get differing, and even if an NDA covers that, like a lot of companies don't even want you to know that they're using, the brand of endpoint security that they're using.
Well, that's right. Because I think here, part of the requirement in the disclosure would be to disclose which third parties that you're working with, as part of your risk management program, right?
Oh, wow.
So do you arguably, right? So do you really want?
So now I have a target list. Now I know who to attack.
Exactly. And I think that people are really concerned about that. Is it enough to say, company X have hired, a third party, risk management company, right? Or a third party vendor, and that's it, without disclosing more as far as the actual specifics. And right now it's unclear, but when they're asking you to describe the policies and procedures and what is being done, I'm not sure that it's enough to just talk in a general way about the actions that you're taking.
I guess it's good that they have the comments period, and I think they might have even extended the comments on this, but I'm counting 170 comments on this one proposal, and it's always, the comments are all public, so it's really interesting to see who they're from. Like a lot of them are from founders and executives at cybersecurity companies. Of course, like you're trying to subtly shoehorn in some kind of advantage for them. But yeah, fascinating stuff to read through, and we still do have some more. If there's nothing else, that's kind of key here that we missed, if you want to, we can discuss the other proposal as well.
Sure.
Yeah. So the other big SEC proposal, which I wanted to discuss a little bit because I've seen a lot of misunderstanding of what it's actually requiring and what it's actually asking companies to do. But at the same time, I think I might be splitting hairs on it a bit. So the way a lot of people interpreted this other proposal is, oh, we have to have a CISO on our board now, or we have to have a security expert on our board. When Jennifer, what does it actually say?
Okay, so my reading of it, and I definitely think that there's a split in the interpretation of the requirement about having a CISO, cybersecurity professional, actually sitting on the board. I think what it's saying is that if you do have a cybersecurity professional sitting on the board, then you have to disclose the expertise of that cybersecurity professional. in my mind, in a way that makes it almost a de facto requirement, because it will stick out to a certain extent if you don't have a cybersecurity expert sitting on the board. On the other hand, it doesn't explicitly require you to have that. So some people are going to say, you know what, I'm just going to go in the other direction entirely. I'm not going to put a CISO on my board. Maybe I'll have, a cybersecurity professional who comes and speaks to my board or works with members of the board, and that disclosure would have to come out through the risk management portion of the regulation, right? Yes, we have these meetings. Yes, we're being educated. We've seen what the tools are. We know that they're up to date. All this kind of information about the actual practice, but not having to actually sit someone on the board. I think you could probably find, if you survey 10 people, 5 who say it's required and 5 who say that it's not.
Yeah, and it's I think it's really interesting paired with this other one, because it's really kind of, this huge 1-2 punch to companies, just really saying, hey, look, you guys got to help us out here. That like this has been looking pretty bad.
Yeah, I mean, I also think about the size of a company, right? So if we think about data breaches, then because of what we've seen in the news with Equifax and Marriott, Target, right, all these big data breach cases, you think of large corporations. So you also think, well, they probably have a number of cybersecurity professionals that are already on the payroll. And so the question is, do we want to elevate them to the level of the board? A thought that I've had is, what if you are a smaller company, but you're still publicly traded, right? So maybe you don't really have that level of depth yet on your bench to have someone like that in-house. And now you've got to go and find someone and put them on the board and learn of it, right? It's a heavier burden, I think, depending on the size of company that you have, and also the line of business that you happen to be in. For some companies, this will come very naturally, and in some instances, it may already be happening. But for others, it's like shock.
Yeah.
So
on the one hand,
in terms of that, so sort of merging the last two questions here. So there is no requirement, or there is no expected requirement to have a cybersecurity executive on your board, but then some companies might opt to use like a VCISO, a virtual CISO. So would that effectively, per these new laws, new regulations and standards, would that make that person a part of the company, even though they're technically not? How would that work? What would the reporting structure be? What would the requirements be if a smaller company went with a VCISO, so they have the expertise without having them be an official part of the company?
Look, it gets a little dicey in my mind, right? Because if the person is not actually on the board, right, the obligations of that person to other board members and to the company and the employees and investors of the company are different, right? The board comes with its own sort of fiduciary responsibilities. So when you have sort of a virtual CISO who's coming in, I wonder if that reads more like a third party situation. Does that disclosure come as part of explaining what we as risk management, or members of the board who are evaluating our risk management procedures, do we disclose that we are using an outside virtual CISO to help guide us and, better prepare us for an incident? Maybe you want to disclose then what the credentials of that person happens to be, but I don't think it would be required. I'm not even sure that it would be required to disclose that you're working with them, although I don't see the harm in doing that, because I think part of, part of the intent here is to say, like, are you taking any steps at all to educate yourself and be prepared for a cybersecurity incident? So as a smaller organization, you might be able to say, look, I'm being proactive to the best of my ability in case something should arise, right? And I think that will help you to say that you've met your fiduciary responsibilities as a board of a company.
Yeah, I mean, if I think through what I could see people actually doing here, I kind of see a mix of things, right? Like I see maybe some training classes or even certifications, like a 1 day, board member cybersecurity boot camp type of deal. Um, Anything from that to, like what Katie just said about the VC. So I think that's probably going to be the most common one, especially for small to mid-size companies to reach for, where maybe this VC so just shows up to the board meetings and does a 15-minute presentation on the state of threats, or something like that to the organization. But I agree with you. That person, they don't have any skin in the game. They're not beholden to the company. They're just hired help stepping in. But I guess, does it all just come down to optics? Like, they're requiring you to disclose what you're doing, and I guess it's up to investors and the general public to judge that, right?
I mean, I think, that's sort of always how it's been, right? This is just a new category by which we can evaluate the responsibility of a company that is publicly traded. It's just another, at least more obvious area of risk that can't be ignored any longer. So, is it just the optics? Probably initially it will just be about the optics, but I think as it gets tested and when you see major incidents, and then you go back to, some of the things that we've already talked about, right? Did you, as a company, whether it's a virtual CISO or bringing somebody, onto the board, did you learn the language? Did you learn what the risks were, right? Did you have an incident, response plan in place? Does it work? Did you bring any tools on board? Are they up to date, right? Did you just install something and then you walked away from it, right? Now it's no longer about the optics. It's not enough to say, oh, we did this. There's got to be follow-up, because when the incident actually comes, all of that is going to be scrutinized. And the investing public is going to want to know what kind of steps were taken.
Right. It's probably not accidental that these two proposals came within a month of each other, right?
Right. I don't think any of this is an accident, right? I think it's sort of been, building up this way. And I do think it dovetails with the state privacy regulations, even though this is specific to cybersecurity, right? All of these issues are, sort of inextricably wed at this point, right? Knowing what your data is, knowing where it is, knowing how it moves throughout your company, right? All of that is really a reflection of, your data footprint, and the amount of risk that you have. And ultimately that risk is what makes you susceptible to the cybersecurity incident that you're now going to have to report, right? So I think it's just another signal to companies to, kind of clean up the house. That data has intrinsic value. It's no longer okay to take in personal information, and not have some methodology in place for protecting it, and decreasing the risk to both, customers, employees, and investors.
Yeah, definitely. Yeah, and I've long wanted, I think it would really benefit the industry to get more details about incidents. But, in my opinion, I've always thought it should be anonymized. Like we don't know. Well, I mean, there's legal reasons, obviously the SEC, is going to require seeing certain things, but when we get into the really detailed stuff, like, what products we're using, why did they fail? Why didn't they save you in this situation? All that stuff I think could benefit the industry, even if it's anonymized. So, on the one hand, I hope we get more details because it'll help us fail less, I think. But on the other hand, I hope we don't overstep and cause more harm than good. Again, right. we've heard about extortion crews hitting insurance companies, to basically to get their target list, because then they know exactly how much insurance will pay out. So that helps them price their extortion amount, their ransom amount. Right. So like something like that. Like I don't want to provide more tools, now.
Right.
the cyber criminals are experts at searching on Edgar and pulling, reading.
Right. And sort of to the point that I kind of stumbled on before, right? If you've decided if your only tool against a cybersecurity incident is to have the insurance, right? If I'm, sort of a bad actor and I get this list of, who has gotten the insurance, that might signal to me that that's all that they have, or at least that's a good place to start, because maybe they just thought, well, I'll get the insurance and not do much else. So.
Yeah, and on the other side there, we've seen insurance providers, putting a bit more controls around, in what scenario they pay out. So if you're overly negligent, like they don't want to just, in the early days they paid out for just about everything, but that period I think is over now. Yeah, good stuff. Jennifer, it looks like you are speaking on September 27th at InfoSec World.
That's correct. I think mid-morning. I'm in one of the morning sessions.
Yeah, 1:10 a.m. on, I'm looking at it, Tuesday, September 7th.
And by then it might be an even broader conversation, right? Because we might have more commentary. We might have an actual, not a proposal anymore. Some more concrete thinking on what steps to put in place to deal with all of these questions, because I think the commentary is leading us to just that. Anybody that you speak to, depending on their role in the company, will have different questions and different perspectives about how to approach these regulations. And I think an important, sort of action item for all companies is to consider all of the different angles when starting to set out your plan.
Well, hey, what are you even doing if you're not updating your presentation the day of the talk, right? Like that's tradition. That's tradition around here. Jennifer, thank you so much for joining us on Enterprise Security Weekly today.
Thank you.
All right, we'll be back in a few moments with our final segment on identity innovation.